afternoon, wherever you're tuning in from around the world. Thank you so much for attending this research seminar, especially during the ILC, when I know that many of you are quite busy with other responsibilities. I'd just like to take this opportunity to welcome Professor Vania Brino to the research department, and to thank her for, on behalf of the research department, for doing this presentation. I'd also like to thank my colleague Tamina Karamova for, it was actually her suggestion that we do this seminar. So what we'll do is we will have a presentation for 30 minutes, and then we'll open it up, maybe 20, 30 minutes max, and then we'll open it up to questions from you. Before we get started, you already have Professor Brino's bio, but I'd just like to say a few words about what she's been doing and how this presentation is relevant for us in research and for the ILO as a whole. Professor Brino is a full professor in the Department of Economics, although she is focuses on labor law, in fact, international labor law. She's a full professor at Department of Economics at Ca' Foscari University, Venice. She teaches labor law and sustainability, welfare law, international labor law, and labor law in transnational firms. She's the coordinator of the Masters in Labor Law and Welfare Law and Scientific, and she's also the scientific coordinator of the Master in Global Economics and Social Affairs at the university. So it's quite an impressive mandate that she's working with. She's written numerous essays and contributed to journals and publications in Italian, as well as English. In fact, a lot of her writings are in Italian, and she wrote a book in 2020 on global value chains and labor rights during that year. Her research is mainly focused on a very topical area for us at the ILO right now: global value chains and workers' rights, sustainability, labor law. She's working on due diligence, workers' right, and trade agreements. The presentation today will be focused a bit more on due diligence legislation, but I'm sure she'll open it up to a broader area. So without further ado, I'd like to turn the floor over to Professor Brino. Thank you again for being with us today.
Thank you so much, and it's really an honor for me to be here and to have the possibility to share with you my research. So I prepare a PowerPoint presentation just to be more clear. I would like to focus on the really controversial relation between global value chain and labor rights. That's my research topic. As I said before, I wrote a book in 2020 on this topic. And let me say that in Italy, there was no discussion on that. So it was the first book which analyzed this kind of really challenge topic, also according to a labor law point of view. So my plan is composed of three main parts. In the first one, I just stress the global framework and some points really useful to describe this framework and its complexity. Then I just point out some critical issues and also the challenges posed by this complex scenario on labor law point of view, from labor law point of view. And then finally, some considerations on the global trends that we could observe in the last 20 years in terms of new regulatory techniques useful to improve better working conditions in the global value chain. Of course, this kind of topic is really complex because we should consider a lot of key open questions. So I don't have a possibility to go more in detail on all these questions, but it's important that in our debate we have clear that these are really a key points for our discussion as scholars. So I just put some of them. The evolution of the regulatory space, of course, introduced some questions related to the interconnection between different legal tools, but also the question related to the different normative needs in different regions of the world. And again, the key question in terms of effectiveness of these tools, which depends, of course, on their design and also their implementation. We have also other open questions in terms of domestic or international accountability. Of course, the issue related to international legal personality of company, and so on. So I just put this in the first slide to say that we should face with this really not easy question for scholars and according to a legal point of view. Of course, in our framework, it's obvious that we have the big players such as global value chain as a dominant economic model. It's obvious that this model introduced some governance gaps. And it's also obvious that we need to push a sort of polycentric governance system. And we observe a work in progress process in this topic, also thanks to a growing global consensus on the need for businesses to respect human rights in an active way. Of course, one really key point, I don't have the time to describe this, but of course I consider in my research that there is a controversial in terms of meaning. So value chains or supply chains. Also in the ILO documents, we could find value chains and also supply chains. So I don't have a time, but I want just to remark this point and the differences on these two concepts. Generally speaking, in this presentation, I use value chain. So in terms of framework, let me just stress 2 points. I think that you know very well, but just to remark the fact that companies assume hybrid models, such as networks, platforms, and of course, global value chain. And why is it so important for scholars to discuss and to analyze this model? Because there is a sort of pulverization of contractual relationship and a responsibility crash, let me use this expression, due to the fact that each entity which composes the global value chain is responsible just for its employees. And that's a really important point according to a legal point of view. Second point really obvious, we discuss on a global market. So we know that corporations could easily bypass the national law. And we know very well the so-called social dumping, forum shopping, also normative dumping, so the competitions between countries based on labor cost. And this complex scenario introduced some critical issues in terms of how is it possible to control what happens in the global value chain, but it's also important to discover human rights violations, and it's not easy. I just mentioned the undeclared war, complicity, or corruption. And finally, we have a problem to identify a legal responsibility, especially of the lead company in the global value chain. So this complexity, this critical landscape, of course, could be summarized using a sort of common picture. Company is irresponsible, business is unsustainable, because company try to escape to the regulatory power. And that creates challenges in terms of new asymmetries, new risks, new needs, and also, of course, new gaps in terms of responsibility. So starting with this controversial scenario or context, what about the reactions by legal systems? Of course, we know very well that in the last 20 years, we have a lot of new statements in terms of hard law and soft law related to this topic. And in my research, I try to identify some common trends at international, at global level, which describe this kind of reactions by legal systems. So as first point, I think that we should reflect, and at legal level, we reflect on the introduction of new statements and principles which can be beyond the bilateral contractual relationship between the employer and the employee. That's really a key point in the sense that we should push on the liability of the lead company, of course, for what the company does, but also for what the contractors, suppliers, and subsidiaries do. So the idea is that we should reflect on the possibility to extend the responsibility of a company and to create a strong link between profit, power, control, and responsibility. That's a strong challenge for us, of course, for the reasons that I mentioned before. But this kind of trend is in reality. So it's not just in the future, but it's also nowadays we could find some statements and some elements which support this kind of trend. For instance, in Europe, we have a trend related to the possibility to identify a responsibility of the parent companies to oversee the activities that happens within their supply chain, as in the case of Vedanta or other case of Kpabi. And also, if you focus on the updated OECD guidelines for multinational enterprises on responsible business conduct, we can find this kind of new legal approach. In this moment, when during this seminar at OECD, there is the discussion on the new text of the OECD guidelines. So it's a strange context. Second point, what about the possibility to go beyond the ex post liability model? Why? Why is it so important? Because it's, of course, we should recognize a responsibility in case of violation of workers' rights. But it's also important to stress the responsibility to prevent the violation of workers' rights as and we find this kind of approach in the European Union proposal on due diligence, but we could find this kind of regulatory approach also if you analyze the disclosure regulation in terms of transparency at European level, but also at national level. So ex post liability should be combined with an ex ante liability. That's a key point. And I think that the due diligence as a new paradigm could really go in this direction. Third point, we should reflect on labor law side, of course, but also we should reflect beyond labor law. Why? Because also in other matters, we could find the statements and commitments useful to improve working condition, even if these principles, these tools are not finalized to improve workers' rights. So, for instance, if you look on the international trade and investment agreements, we can mention the 10 principles for integrating the management of human rights risk into contract negotiation, or the agreement between US, Mexico, and Canada, which contain important references on the interconnection between business and human rights. But also, if you consider the European Union taxonomy or the sustainable finance regulation. So I don't have a time to go more in detail on this kind of new tools, but it's evident that there is a common direction also if you look outside labor law matter. And finally, but the ILO is a sort of front runner in this sense, we should push the creation of a global labor law. So we should try to go beyond national law in terms of protection. And that's a really key point for us as scholars, because in the last years, we observe the strong use or the new use of regulations that will have extraterritorial effects. As in the case of due diligence, I think that it could be a good example to say, okay, we could go beyond a national legal system, and it's possible to introduce some principles or statements which have an extraterritorial effect. So if you, just to make the point, of course, we can identify at the heart of a process the fact that the company should be full transparency of its human rights impacts. That's a sort of mission, not mission, that's a sort of common element in our discussion. And also at legal system, we can identify an evolution in this kind of context, in the sense that if you look on the more in detail on the legal reactions by international institutions, by countries, we can identify two main points. So new interventions in terms of liability of company, as in the case of due diligence, and also a strong intervention in terms of transparency. So, of course, we have a smart mix of measures at international as at the European national level. I just mentioned the United Nations Guiding Principles on Business and Human Rights, but also at the ILO level, we have a lot of statements and documents really important as the M&E Declaration, Business and Decent Work. It's also important to say and to observe that at national level, we have a positive contamination between these kind of new statements focus on liability and transparency. Because if you look on this map, you can see that liability and transparency are really the main driver in this kind of legal context, and it's not only inside Europe but also outside Europe that we discuss on this kind of new provisions focusing on liability and transparency. And it's also important when we discuss a global value chain, it's also important to consider what happened at enterprise level, not only in terms of corporate social responsibility or the use of code of ethics, for instance, but also it's really important for us as labor lawyers to consider the role played by the international framework agreements. Especially, let me mention the really positive case of Inditex and Uniglobal Union. It's really a best practice in the field of international framework agreements, because try to define a common rules in terms of protection for all the workers involved in all the global value chain of Inditex. Another important point, just in terms of general consideration, but it's important because I want to fix this element. So if you look on the legal systems, we can really observe a fast reactions in the last 20 years at international and at European national level. And it's really important to say that these reactions are linked. So international level, European level, and national level create a sort of positive contamination. Also, if you reflect, for instance, on the European Union new proposal on due diligence, this proposal is a way to implement the UN guiding principles on business and human rights, or the French law on due diligence is another way to implement the principles introduced by UN in 2011. So in my presentation, I think that it's important to reflect on the due diligence, because it's a sort of new paradigm when we discuss on a global value chain and labor rights. Due diligence has been introduced in the UN guiding principle, but finally, as an important as said in an important document, there is no one single model for mandatory human rights due diligence, and that's important. So we recognize this new paradigm, but we take into consideration also that this new paradigm could be implemented in different way according to the different needs and different situations inside countries, inside enterprise. That's really an important point. And of course, this new paradigm could be considered as a process that companies should put in place to prevent, that's the point, to prevent, so it's an example of ex-ante liability. Company should prevent the violation of workers' rights and human rights. So it's a process. It's a process that could change in relation to the new needs, new risk, of course. It's a process which should involve all the stakeholders. That's another important point. And if you look on the new EU proposal approved the 1st June, the European Parliament stressed the need to involve all the stakeholders, also trade union, in this kind of process. All these steps are part of this process, so identify, choose, prevent, mitigate, and so on. All these steps are part of this due diligence process. And of course, I know that there are some problems in terms of implementation. Maybe during the discussion we could say that. But I think that due diligence is really, how can I say, our roadmap for the future. Because also, if you look inside the legal national provisions as French law or German law, we really observe that due diligence combined with all the other tools mentioned before could improve and could mitigate the risk, but also could create a sort of new active approach on business in relationship to the implementation of workers' rights. So I have a lot of things to do, of course, but I know that the time is not so much. So let me just say one thing on the European Union, because it's really an important point, I think. So we know that when we discuss of this kind of tools, we have a problem in terms of effectiveness, because I mentioned before, no, this key point. But it's interesting because in French law, in Germany law, and also in the European Union proposal, there are a lot of new provisions which render more strong the effectiveness of this due diligence process. And just 2 points. The first one is related to the creation of a new administrative supervisor authority at national level, but also at European level. And that's important. Also in the Germany law, we have this kind of new actor, important in the implementation, of course, of the due diligence process. And the second one is the new responsibility for director inside company. That's another key point which could help a lot the implementation in reality of this kind of new provision. Okay, I consider the time, Marva, so I think that I don't have so much time, but
okay, thank you, Professor Brino. That was a very, very, it was comprehensive presentation. Thank you for giving sort of the background in terms of theoretical framework, but also giving us some examples. I wonder if, just before turning it over to questions, and there is a first one, I noticed as you were flipping through your slides that you were about to present, you had one on the German due diligence law in this first case, because I think a lot of us would also be interested in this effectiveness. So if you could say something about the first case that was submitted under that would be great.
Yes.
Thank you.
Thank you, Marva. It's really an important case, is related to German law. So it's the first complaint against Taylor, Amazon, and IKEA. And it's really important also in perspective, I think, because, okay, Germany law introduced a due diligence process in a strong way compared to the French law. So also in this, how can I say, in this context, we stress a positive evolution, because French law has been introduced in 2017, German law in 2022. So in this evolution, we observe that Germany law is more strong in terms of content compared to the French law. Okay, so Germany law introduced some principles and provisions related to the due diligence process, similar to the also the European Union proposal on due diligence. But this complaint is really important because human rights organizations have filed a complaint. Why? Because they think that these three companies are not are not signatories of the Accord on Fire and Building Safety in Bangladesh. As we know, this accord is a legal binding agreement, and its focus on health and safety risks. So according to these NGOs, the companies don't consider this accord. And that's an element which shows us that these companies violate finally the provisions contained in this new due diligence law. I think that it's really an important point because according to these NGOs, there is a strong problem in terms of recognition of the legal relevance of this accord. And finally, we can say that the application of this accord could be considered an element which shows us that the company is in line with the due diligence process. So there is a connection, there is a possible connection. Of course, we will wait the final judgment, but it's interesting because the question is it possible to consider the application of this kind of international accord as an element which shows us that a company complying with the new legal provisions in terms of due diligence? And that's really an open question also for scholars, because it could be really a good point to stress and to improve the liability of company in terms of due diligence process.
Okay, thank you, Professor. I really appreciate that. Without further ado, I'm going to turn it over to some of the colleagues who are in the presentation. I see we have quite a full session, and there's some, especially with some colleagues who are working in this area. I see Caitlin, Ariana, Franz, so I'm sure they'll have some questions for you, but I'll kick it off with the question in the chat from Ken. Welcome, Ken. His question is, great presentation, and he wanted to know if you considered the ILO's own M&E declaration on multinational enterprises and social policy, and how the guidelines therein link with your work. So in taking into consideration, some of the instruments at the international level, did you take into consideration the ILO M&E declaration? Because it was, for ILO, it was an obvious missing point in the presentation.
Yes, of course. The ILO, not only the ILO declaration, but also the ILO resolution on supply chain and decent work and other documents introduced by the ILO are really a strong part of my research. Today I just mentioned it, but in my book, a chapter is dedicated to the ILO approach, because it's really true that the ILO could be considered a front runner in this matter, in this topic, compared also to other international institutions. And we can say that the ILO give give the roadmap also to the other international actors and also the national countries, of course. And it's really important because in the also in the resolution of the ILO 2016, in this resolution is really clear what is the main problem related to the global value chain, but also what are the possible solutions to mitigate this kind of governance gaps. So, of course, the ILO is really, how can I say, a fundamental player, not only in my research, but generally speaking, when we discuss on this topic, we should face with the rich intervention of the ILO.
Okay, thank you for that, Professor. I cannot see for some reason the hands that are raised, but I do see that there's one hand raised. But I can't, there we are, that's Franz. Please go ahead, Franz.
Hello, can you hear me?
Yes.
I can't hear you, but you sound a bit distant.
Do I?
Yes. Do you have your mic down on your headphones?
I do. I'm speaking right into it.
Okay, well, it's okay. We can hear you. Okay.
Okay, I speak up. Yeah, thank you so much, Professor, for this very elaborate and skillful presentation. I think you brought out very vigorously the proliferation of governance instruments regarding supply chains at all sorts of levels, domestic, international, public and private. And I think similar to what Marva already said, yeah, I guess that one of the key challenges is to understand what are the effects of these instruments, how do they interplay and interact with each other, and which of them are perhaps also not that effective and more window dressing, whilst others may be quite transformative. In this slide, I have two perhaps more specific questions. One relates to the relationship or the dynamics in supply chains and how the instruments that you have mentioned might be able to influence them. So some of the global value chain literature highlights that the poor working conditions in supplier factories are often driven by the dynamics created by buyer companies. So, for example, by the conditions that buyer companies impose on suppliers, which then translate into poor working conditions in the supplier factories, for example, by requiring supplies being produced at very low rates or at a very short amount of time. Against this background, what possibilities would you see to induce buyer companies to create conditions for supplier companies that facilitate better the respect of labor rights in the suppliers' factories? That is my first question. My second question would be, could you elaborate a bit further on possibilities to pierce the corporate veil to hold buyer companies accountable? You mentioned the Vedanda and Okapi cases, but courts indeed, as you have also alluded to, have so far been relatively reluctant to hold parent companies liable for human rights and labor rights violations committed by their daughter companies. And I would be interested in your views about doctrinal and legal strategies that are available to increase accountability for parent companies. So, for example, do you see potential for tort law? Do you see potential for competition law in this regard? Or should we look really more to these new laws, such as the German Supply Chain Act, which of course come with their own limitations in this regard? Thank you very much.
Okay, thank you for your really important questions. I don't know if I can answer in a completely way, because you stress two really critical points, of course. So related to the first question, I think that we, how can I say, we observe a positive interconnection between all these statements, all these tools. So it's not possible just to push attention on one of these, but it's better, according to me, to reflect on the connection between all of these. For instance, just to do the example of the trade agreements, it's really important to introduce in a trade agreement some references to these kind of tools, to not only in terms of corporate social responsibility, but also in terms of due diligence process, and so on. It's just an example. It's just an example, but we observe this kind of evolution also inside trade agreement that's not focused on the protection of workers' rights. So I think that we should improve this kind of connection. Of course, if you look on the relationship, contractual relationship between all the companies which compose the global value chain, I think that we should really push attention on this kind of relationship in terms of control and power. And when we identify a control and a power, we should identify also a responsibility. So for this reason, I think that also in the future, we need to introduce new rules, new tools, which could be useful to create this link. Because generally speaking, we consider the economic asymmetry between the employer and the employee. But if you look on the global value chain, we have a different problem, because there is an economic asymmetry between the leader firm or leader company and all the contractors and subcontractors. For instance, in Italy, we have norms which define a ex post liability of a company involved in the supply chain, but it's not enough. We should also reflect on what happened before the violation of human rights. And in this context, also the leader company must have a liability. Because, as you said, if the leader company fix the conditions in terms of price or in terms of timing for the production, of course, this power has a strong impact in terms of the working condition of the employees and of the workers employed by the contractors or subcontractors. So I really think that this is our need. So we should really push on this kind of context. It's not enough to consider the bilateral relationship between the employee and the employer, but we should consider the contractual relationship not only inside the group, as in the case of multinational corporation, but also when we have a contractual relationship between companies. Maybe I forgot the second question, because it's a lot of things to do, to say, and maybe I forgot the second question. Is more related. Sorry, Franz.
Franz, do you want to repeat that second question? And maybe I'll give you another one, and then Franz could come in, because I would like to take a round of questions, but they seem to be trickling in. So colleagues, please, if you have a question, raise your hand. The second question, the next question is from Caitlin. She has it in the chat. She wants you to elaborate, in fact, going a bit further. You touched on it slightly further than what you just did. Elaborate on how the power relationship control should be assessed. So how do you assess the power relationship and the control, and who should do the assessment of that? And what kinds of categories might there be? I don't know, Caitlin, if you want to come in and say something more on that.
Sure. Can you hear me?
Yes, fine.
Okay, great. I can't make my camera come on, I don't think so. Thank you very much for the presentation. No, I'm just curious if you could discuss that the power relationship control angle of your framework a little bit more, because one company might assess that they have a significant amount of control over a joint venture or a daughter company, but that's not the only kind of relationship that we would have or find. But also, like, there might be different different perceptions of power and control. So who's making those decisions and how, and what kinds of guidelines would you propose both companies and perhaps other stakeholders follow in assessing that?
So
Thanks, Marva.
I think that can I say, of course, it's not easy to introduce a new tools which could link the power to the responsibility. Because according to a legal point of view, the employer is responsible for its workers. That's true, that's enough. But it's also true, and I think that due diligence try to introduce this new approach in the sense that thanks to due diligence process, the leader company should take into consideration what happened in all the value chain in terms of risk. So if I have a control on my contractors or suppliers, and that's true, I control my contractor, I should know what happened inside my supplier or my subcontractor. Of course, it's not easy, but if we introduce a process as the due diligence, we could enforce this kind of approach also inside business. So for company, it should be really important to know the quality and also the behavior of its supplier, because it's a way to prevent the violation of workers' rights. It's a way to prevent the scandals. It's a way to prevent the possibility to go in front of a tribunal. So it's a completely different approach. So I should consider what happened in my supply chain because it's useful for me as leader company. I want to know that, not only because if there is a violation, I can enter in a context or in a contract, of course, but it's also important to improve my brand, my image. So there are a lot of reasons. And I think that thanks to due diligence, we will try to modify the approach inside business. For instance, many scholars reflect on this topic, mention also the a sort of shift from a shareholders approach to a stakeholders approach. And I think that due diligence could be really useful to go in this new direction. So the idea that business should take into consideration what happened in all the global value chain, because it's good not only for its brand, but also for community, for the workers, for all the society involved. I don't know if I
No, that's fine. Thanks a lot, Professor. We have a question now. I see Dan Rees has his hand raised. Do you want to go ahead, Dan?
Thanks, Marva, and thanks, Professor. Really interesting presentation. You spoke about the possible significance of extraterritorial effects of due diligence instruments, and I've got a couple of questions about that. I think one is, do you think that any particular effects would be impactful, most impactful for workers in supply chains? If you could be more specific about that. And the other is, do you envisage any potential conflicts or downsides between extraterritoriality and the direction that that's going in and national legislative structures that, after all, are designed to, at least in theory, to police the governance of labor markets, including in supply chains?
Thank you. Because extraterritoriality is really another strong point in my research, in the sense that if you look on the past, we have just one example of a statement which has a direct extraterritoriality effect, such as the Tort Claims Act in US. Mm-hmm. It's really important because this law has been used against big multinational corporations in US, also in case of violation of human rights. But it was a statement which has a direct extraterritorial effect because it's contained in this kind of provision. And it was really controversial because in the last part of the history of this statement, finally the US judges decide to reduce the application of this kind of very important instrument in terms of enforce the liability of company. So in the past, we have just this example. Nowadays, of course, the question of extraterritoriality is again controversial between scholars. There is a problem to tension between national level and international level, of course. So we have all these kind of controversial issues when we discuss of extraterritoriality of law. But finally, we can also identify some new tools which could be extraterritoriality in their effects. So as in the case of due diligence, for instance, it's really a good example because if you look on French law, so all French companies should introduce a vigilance plan, okay? And it's not a law which has extraterritorial effect in direct way, because it's only for French company, that's all. But finally, if we consider that French company should mitigate the risk related to all the value chain located in different countries, finally, we have an indirect extraterritoriality effect because we extend the protection introduced by French law for all the workers involved in the global value chain. I don't know if it's clear because it's really also according to a theoretical point of view, it's not so easy, but also if you look on some ILO documents, the ILO introduced this new approach. And the ILO said, okay, it's important to reflect on these tools which could have an extraterritorial effect. I don't know, Marva, if...
No, that's fine. I don't know if Dan or I realized Franz, I didn't have let you follow up to Franz's second question either. I don't know if they want to come in with anything else. And if not, I'll reserve the space for a last question before we wrap up. Did you want to come back in, Franz or Dan, on that?
Dan, if you would like, I can repeat my question.
Sure, please, thanks. And apologies for that earlier.
Not at all. No, my question was basically if you could elaborate a bit further on possibilities to hold parent companies accountable for human rights violations committed by their subsidiaries. This seems to some extent to be the Achilles heel of some of the new supply chain instruments that have been adopted and are currently under deliberations, like, for example, with the global supply chain law, with the German supply chain law that excludes civil liability against companies. And this slide, I was wondering whether you have any insights or perspectives with regard to legal strategies that could be promising to increase accountability for parent companies? Should we go the tort law way that has, for example, been tried out with Vedanta and similar cases? Should we try to rely on competition law? This is sometimes being proposed in legal academia as a way to get a hold on parent companies. What would you think are the most promising avenues in this regard?
Okay, so I think that we should use tort law, of course, and we should also, as in the case of Vedanta, the concept of duty of care. We need to improve this kind of regulatory approach, of course. And if you look on the German law, finally, we can find how can I say some provisions which could, thanks to the vigilance plan, so the due diligence process, it's a way to prevent the violation of workers' rights. So I think that we need to enforce the duty of care, the tort law, but we need also to enforce the all the prevention mechanism to mitigate the risk of violation. So I think in the future, I think that the Danda case is really a best case in this direction. And the Danda case use the duty of care as a way to stress the liability of headquarters in front of the employees of the subsidiaries and suppliers. So we need to combine these two different perspectives to push a new responsibility in a business company, I think. I would like just to conclude with, because I forgot, I think that it's a sort of message for all of you, all of us, and I think it's good, a sort of way to summarize also what is the challenge for our future. Okay, just to. Of course, I can send you my presentation and
Of course, thank you. And in fact, I see the time is 12 o'clock and I'd like to stick to the time. So I'll reserve my last question for the next seminar, or perhaps follow up with you. I would say 3 requests. Yes, please do share your publication. And we would really welcome a follow-up discussion. And also, whenever you translate your book from Italian, let us know, because we're all looking forward to reading that, except of course those who are able to read Italian. So thank you so much, Professor, and thank you for everyone for participating. And with that, I'll go ahead and close the seminar. Thank you.
Thank you. Have a nice day.
All right.